I remember how quiet he was when they brought him in. No attitude. No arrogance. Just silence. The kind people mistake for weakness. He sat alone at the defense table in a faded gray hoodie, hands folded calmly in front of him while whispers moved through the courtroom like wind through dry leaves. Too young. Too quiet. Too calm. That's what they saw. The prosecutor barely looked at him before speaking. Your Honor, this young man clearly doesn't understand the seriousness of these proceedings. The judge nodded slowly. An older man with tired eyes and the kind of confidence that came from years of never being challenged. He glanced down at the teen. You've chosen to represent yourself? He asked. The boy nodded once. Yes, sir. A few people in the room laughed softly. The judge smiled. Not kindly. That's ambitious, he said. Especially for someone with no legal education. More chuckles. The teen didn't react. Didn't lower his eyes. Didn't shift in his chair. And somehow, that silence irritated them more than anger would have. The prosecutor opened a folder dramatically. This case is very straightforward, he said. The evidence is clear, and frankly, I don't expect much resistance here. The judge nodded again. Good, he replied. Let's avoid wasting the court's time. The words hit the room like a verdict already decided. The teen finally stood. Slowly, calmly, and for the first time, people actually looked at him. Not through him. At him. He cleared his throat softly. Your Honor, he said. Before we continue, I'd like clarification regarding the admissibility of Exhibit B under Rule 803. Silence. Small at first, because nobody expected that sentence to come out of him. The prosecutor frowned immediately. What? The teen didn't look at him. Rule 803, he repeated calmly. The hearsay exception being used here doesn't apply because the witness statement was prepared after the investigation began. The room froze. The prosecutor blinked. The judge straightened slightly. And suddenly, the laughter disappeared. The prosecutor recovered quickly. That's incorrect, he snapped. The teen nodded politely. No, sir, he replied. Actually, subsection 6 specifically excludes documents prepared in anticipation of litigation. Silence again. Heavier now. Because now, people weren't amused anymore. They were listening. The judge leaned forward slowly. Where did you learn that? He asked. The teen shrugged slightly. I read the law library records online, he said. Then I checked prior rulings from this district. No pride. No showing off. Just facts. The prosecutor stepped forward aggressively. You think reading a few cases makes you an attorney? The teen looked at him calmly. No, he said. But it does help when the prosecution misquotes procedure. A woman in the gallery covered her mouth. Someone else whispered, Oh my God. The prosecutor's face tightened. Young man, you are out of line. No, the teen interrupted quietly. And somehow, that quiet interruption hit harder than shouting. You're asking this court to admit evidence that violates its own procedural standards. Then he reached down, picked up a folder, opened it carefully. I also found 3 prior rulings from this judge rejecting evidence under the exact same circumstances. The courtroom stopped breathing. The judge's expression changed instantly. Because now, this wasn't confidence anymore. This was exposure. The teen handed the papers forward. Calm hands. Steady voice. No fear. The judge took the documents slowly. Read them. Then read them again. The prosecutor stopped talking completely. Because the teen was right. Every word. The judge looked up at him differently now. Not like a child. Not like a distraction. Like a threat to every assumption made about him the moment he walked into that room. And as silence swallowed the courtroom whole, I realized something I'll never forget. The moment they mocked that quiet black teen was the moment they stopped realizing he knew the law better than the people trying to judge him.